So we're here with Marc Garneau, who's the liberal critic for industry, science, and technology. Mr. Garneau, thank you very much for joining us this morning.
My pleasure, Matt.
How would you describe the state of copyright legislation in Canada?
Copyright legislation has been in the process of being changed primarily to cope with the technological change that has occurred that has had a profound effect on copyright law. Back in 1996, the Liberal Party signed an agreement at that time, the World Intellectual Property Organization agreement, that committed us to reforming our Copyright Act. And we subsequently came up with a bill called C-60, which was going to make changes that essentially tried to balance between the creator's right to be remunerated and the practical reality that there are a lot of consumers out there who want to have access to a lot of copyrighted material. We were defeated in 2005 or 2006, so the Conservatives subsequently came back with Bill C-61. It did not make it through all the hoops that it has to go through before it becomes law, and it will probably be brought back. I'm guessing here it's the Conservatives who have to decide that. It will probably be brought back for tabling perhaps in the early fall, and at that point hopefully we will get on with the business of transforming it into law.
It's interesting you talk about WIPO because obviously it happened so long ago and yet Canada's never really ratified it. Why do you suppose it's taken the federal government so long to update copyright legislation?
It's an area where one has to tread very carefully to make sure that you try to achieve the right balance between, protecting the rights of the people who create these works, and because they have an entitlement to a remuneration for their creative output, but also at the same time in this internet age that we live in, to make that information available to consumers. And respecting the fact that I think as a principle, which is embodied within that WIPO agreement, that if they're going to use it for their personal use only, that would be, quote, fair dealing or non-infringement, and would not be necessary to invoke any violation of the Copyright Act. And that's a very, very complex issue to deal with. And so achieving that right balance, I think, is partly the reason for it in the midst of rapid technological change. But we do need to come up with something, and other countries are coming up with their Copyright Act. And from the Liberal perspective, the philosophy when we put C-60 together was that we would essentially frame it as principles that should be followed in interpreting Copyright Act, and we would then leave it to the courts to interpret those principles rather than getting specific. And I think the Conservatives have started to get a little bit too specific in C-61, and that opens up all sorts of Pandora boxes, which perhaps are best dealt with through the courts deciding on whether in a specific case a principle of copyright has been infringed.
The Office of the U.S. Trade Representatives has put Canada on what they call a Special 301, which is a list for countries that, quote, deny adequate and efficient protection for IP rights. So with that, do you feel that Canada's international reputation may be being harmed because we aren't doing enough to protect intellectual property rights?
Well, there's no question that I think that it's important for Canada to harmonize its Copyright Act with those of other countries. And in that respect, I think that the Conservatives, rather than when they came into power in 2006, instead of them simply going and internally making changes to C-60 to make it C-61, that's one aspect of a government has a right to do that, but at the same time they should have gone towards established models that exist in other countries such as the United States, New Zealand, Australia, where they are actually much more advanced in terms of dealing with copyright in this new age, and should have inspired themselves from that. And I think that in that respect we might have achieved greater progress by now and have something that would not provoke this kind of reaction from other countries, but also would have been based on some experience that's already acquired by other countries.
what would your party have changed about Bill C-61, and what would you like to see come from new legislation? Would you like to see a return to that sort of principled approach and leave some of the legal matters up to the courts?
You know, one of the things that both C-60 and C-61 dealt with was giving exemptions to internet service providers and search engines, essentially viewing them as the distributors of material, the infrastructure. But there are, for example, now file sharing sites that provide a lot of copyrighted material quickly to a lot of organizations, and there perhaps we need to look at, this is no longer simply, they are also at the moment sort of lumped in with ISPs and webs and search engines, but they are in fact perhaps they need to be looked at, because now we're talking about getting back to the spirit and the principles that we're focused on, which is that in this case a lot of copyright is being passed on, and is it simply in the end respecting the spirit of it being used for personal use by the consumer. We have to keep those things in mind as we go forward.
Curious what role you feel ISPs should play in maybe managing the content that's going over their networks, and whether or not they should be playing a role in helping to combat copyright infringement.
I think I view them at this point as being primarily providers of information. In other words, the highway. We're not talking so much about copyright. We're talking about the Competition Act. And if certain sites, certain providers are filtered for one reason or another, then it can raise questions about whether there's preferential treatment in terms of what information is provided. And so that would be something that could give rise to concerns about free competition. So that it's not a copyright issue. I don't view it as a copyright issue in that sense.
No, and that sort of brings me to my next question, which is, how does the Liberal Party define the term or view the term net neutrality?
That there isn't any intermediate mechanism that the ISPs will use to decide whether in any way to restrict or to slow down that access.
And finally, what's the biggest challenge facing Canada as it tries to move into this, as it tries to update its copyright legislation to respond to the sort of digital revolution that's happened?
Well, that's why I think we, in the Liberal Party, decided the best approach was based on principles. And I think if you nail down your principles, then you do leave it, obviously, it's not a question of shifting the onus, but each case is so particular, I think, when somebody is going to come forward and say, I believe that my rights, copyright authors' rights have been violated, or whether it's an individual or a company, I think then the courts can look at that specific issue in that particular context, because a year later it might not be the same context. So I think it's important for us to move ahead with the bill that is going to be put forward. I think that the Liberal Party did a huge amount of consultation in the period since the WIPO agreement to when it had C-60 put forward, and that was a lot of the heavy lifting in terms of consulting, and I think it led to a reasonable number of principles. We run the risk with C-61 if we start to go, or the government does, if it starts to sort of try to get overly specific, of it quickly being out of date and it dragging on forever. So I think that you're not going to get a perfect law by the time you do it. I think what you want to do is to do one that goes back to that fundamental principle of achieving that balance between the creator and the consumer.
Fantastic. That pretty much does it for my questions. Is there anything else we haven't touched on that you'd like to bring up, or any other questions you thought I might have asked that I didn't?
No, I think that it is a very, very complex issue, and it's one that I have to admit it's fascinating to me, because it's every day I'm uncovering something that had certainly not occurred to me personally, and And in that sense, I can understand why it's a complex piece of legislation.
So that pretty much does it for us. We've been chatting with Marc Garneau, who's the Liberal critic for industry, science, and technology. Mr. Garneau, thank you very much for joining us.